Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to another in our series of podcasts on cases, developments, and issues impacting international commercial and investment arbitration. In this podcast, we'll be exploring issues that arise out of the funding of claims. That is, of course, something that's increasingly common these days as the litigation funding sector continues its rapid growth and which has application across many forms of dispute resolution, not just international arbitration. Before we get going, I have 3 housekeeping points I need to run over. This presentation is limited in scope as appropriate for a general audience and applicable time constraints. This presentation is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacities, and any opinions or views offered are those of the speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP, Therium Capital Management, or any other entity or individual. I'm joined today by Tim Mayer, the Senior Investment Officer of Therium Capital Management Ltd. As many of you will already know, Therium is a market-leading funder, having commenced business back in 2009, which in this relatively young sector is very much at the start of the high-growth period. It's raised over $1 billion in capital to support cases, and it now has a real global reach with offices in London, New York, Melbourne, Dusseldorf, and Oslo. Therium backs domestic and international disputes, and they have significant expertise in class and group claims, as well as international arbitration. Tim himself is a senior investment officer with 12 years experience, having funded claims with combined values in excess of $10 billion, including several high-profile arbitral disputes. He was a member of the ICA Queen Mary Task Force, and he's a member of the ILFA Working Group on UNCITRAL Working Group 3. Thank you, Tim, for agreeing to participate in this podcast.
Thank you very much for having me in.
I'd like to start with the basics, if I may. What are you looking for in a claim that you agree to fund? Perhaps you could walk me through the central criteria you use to assess a case.
Certainly. Well, I think that the overarching diligence hurdle is collection risk. It doesn't matter how strong the merits of a claim are if we have a Pyrrhic judgment or award. So we need some positive or comforting optics on recoverability, but we recognise, of course, that across the lifespan of a dispute, things may change. So we're not looking for perfection on that. The second issue, I guess, the second most important issue is concentrating on the economics of the case. Does the estimated costs do the estimated costs square with a likely claim value? The market generally looks for a 6 or 10 times ratio between those two parameters, and we're not really much different. What that means is that the claim value or content has to be 6 to 10 times greater than the costs which we're asked to fund. And we generally adopt that parameter so that we ensure that the claimants will take as significant an amount out of recoveries as possible. Once we're comfortable as to the first two matters flagged, then when we concentrate, of course, on the merits. It goes without saying that whilst we appreciate that no one has a crystal ball and that risk is embedded in the asset class, we don't seek investment committee approval for claims that we think are more likely than not to lose. That may sound silly, but some people have previously said to me in passing, it's just like betting, isn't it? Well, it's not like betting, provided that the prospects are respectable. After we've subjected them to what I think Lord Justice Tomlinson in Excalibur called relatively rigorous due diligence, short of champity, then we'll feel free and comfortable about supporting the case and putting it up to our investment committee accordingly.
Want to focus on the economic viability of the claim front on and collectability. So you're looking at robust cost budgets and a particular ratio against reasonably recoverable damages. How closely do you look at those two components when you're carrying out that assessment?
That's very important. we need to ensure that there's a sufficient proportionality between, or headroom between the funding cost and the size of the claim. In broad brush terms, your rule of thumb is 10 times between the costs and the size of the claim, and you do that for good reason, because we've seen in our experience that quantum may come down in a case, the cost may go up, and whilst of course we invest on behalf of investors who want to make a return, we're also very keen that claimants take something out of recoveries at the back end of the case, and maintaining that approach with respect to the economics is very, very important.
And in terms of your due diligence of claims, I mean, do you use external law firms or barristers? And on damages and collectability, do you ever engage your own damages or asset tracing experts? And importantly here, at your own cost, or are they things that you will be pushing the applicant for funding to ensure that they have to your satisfaction?
We've got a two-tiered approach really for our assessment and our due diligence. And it depends really on the extent of the funding that's required. In the fast track, if I can put it like that, are claims where you're looking for funding around the $1 million mark. And beyond that, you're into the more detailed track of assessments in terms of what we may or may not require. We do assess things internally, not for the larger claims beyond $1 million, but we also go externally for advice, and that can comprise legal advice. It could comprise asset tracing advice and investigative work. And whilst we charge an element of the cost of that to the client, it's not a direct cost without more. It's fundable from the funding commitment up to a small limit. I have to refresh my memory on what that limit is. I think it's $7,500, something like that. The balance of any external costs that we incur, we would fund that ourselves. So it's a small figure in the context of of usually the funding that we're committing into a case.
That's helpful. I mean, those of us in the arbitration community hear a lot of talk about the length of the process involved in securing funding for a claim. I mean, could you explain a little about your internal process, the sort of the steps in it, and how long you would envisage your, I think you termed it fast track, and your longer normal track, just to give us sort of calibrate a sense. And maybe when doing so, you could illustrate how we, the firms acting for applicants for funding, can make it longer, and what we can do to try and speed things up for you.
I think as a rule of thumb, a fast track can take 8 to 10 weeks from the beginning, the first call or the first email to completion. I think beyond, when you're looking at commitments comfortably in excess of $1 million, and most of the commitments we consider in the international arbitration context are far in excess of that. I think 3.5 months is again a rule of thumb that I like to deploy. Just concentrating on the latter, really. I think that one is able to give an indication of whether one's interested in the case or not within a couple of weeks. One may need to consider heads of terms, depending on what the client wants and what the law firm requires in terms of a competitive environment. And I think we can embark on our heavy due diligence within a period of 8 to 10 weeks, coming out at the end by obtaining IC approval, investment committee approval, and then moving to completion. And we can try and speed up things in respect to completion by advancing draft funding documents whilst we're undertaking our due diligence. So I think that's a reasonable timeline. It rather depends, picking up the second point, rather depends on the package that we receive. I do sometimes receive inquiries that are, I won't say back in the fact packet, but I think if I do say that, you can probably glean what I mean by it, where not a great deal of thought has been put into things, where there's an element of speculation about the case, where you may get the sense that you might be being used as a stalking horse. The best approaches are always well put together in terms of the merits advice, well put together in terms of concentrating on the economic issues and also the recoverability issues that I mentioned earlier. And in those circumstances, you can try and truncate your 3 months for a start to finish on a funding deal. There's no reason you should be able to do that. So whilst we don't, of course, expect any analysis to be consist of the turning over of every stone in respect of a case, more is more in this instance, and the better put together a proposal as it would be for anyone who as an observer looking at a case, the better. It puts the client in the better position of obtaining funding as soon as they can.
Thanks, Tim. Conflicts of interest arising from the involvement of funding in international arbitration, I think this is particularly international arbitration, maybe more so than other forms of disputes, has received a lot of attention over recent years. It's been an area of focus for recent institutional rule changes, in part following the large Acre Queen Mary report into funding that I know you were actively involved in. What's your attitude to the early disclosure publication of the fact that Therium is funding a case, and how do you address the risk of conflicts now you have such a large portfolio of cases and through that links to so many people active in the arbitration sector?
I think views have probably changed back at the beginning of time, as it were, for arbitration funding. I think funders are very cautious about revealing their presence and identifying who they were. But I think now mature funders accept that it's very important that there is that information flow for various reasons. I mean, the most obvious one, and again, looking to the end of an opportunity rather than the beginning, we wouldn't want to be in a position where we funded a significant amount into a case which has resulted in a positive award, which may or may not be required to be enforced. And then an issue arises because we haven't disclosed ourselves as to whether there was a conflict between us and one of the arbitrators who'd made the award. So I think at a very macro level, there must be amongst funders an acknowledgement that that's a key issue. We need to have processes in hand to deal with that. Because of the number of cases that we funded, responding to your question on how we assess that, it's a relatively straightforward process insofar as we've got a data bank of claims that we funded, of arbitrators who are sitting on those claims. And of course, we can marry that up with respect to the claims that we've seen from certain law firms and certain individuals, and indeed those claims that we have actually embarked on funding with respect to certain individuals. So we're very keen to do it. We do it very, very, very early, and I think it is certainly at that level sensible that there be a disclosure of the presence of a funder. Although, of course, as you've remarked by reference to the Acre and Queen Mary report, there are various views as to why potentially funders in strict sense should be treated in any differently from other forms of corporate finance, which a claimant may utilise in respect to the progression of its commercial arbitration.
One other question just coming out of that. I know a few years ago there was quite a trend towards a number of leading funders bringing on board leading arbitrators or other figures onto their investment committees to assist in internal review. And I sense that may have been part of the reason for a number of the conflict issues that arose. Now, where do you sit with that? Do you have leading external figures on your investment committee, or have you gone a different route?
That's not a route that we have adopted at Therium. Our investment committee is confident that we're either in-house or externally and managing the legal issues in respect of any dispute, and they like to hone in on the economics and the commercial implications of any funding venture that we might be thinking of. But I think that there are successful funders who have deployed or employed that methodology, and it has worked. It's worked well. But for my own part, it depends on your process. Potentially, if you've got arbitrators on panels and they are presented to in a way that you might be presenting to a court with respect to any particular investment, they haven't been involved in it perhaps at an early stage. There's a potential for that to occasion delays if points are raised that haven't previously been raised, and so on and so forth. But I'm relatively open-minded on it in the sense that we don't do it, others do. I don't think there's a right answer.
For many people, the sort of questions of disclosure of the fact of fundings become sort of interconnected with security for costs and through that adverse costs insurance in jurisdictions that cost shift. What's your own perspective and I guess experience of how you approach those issues? Have you had successful orders for security for costs made against Therium, applications that were unsuccessful? I mean, what do you do in relation to adverse costs insurance for cases that you take forward in cost-shifting jurisdictions?
In terms of security, we're seeing this more and more, and as a consequence of a request from a respondent as to how the claim is funded and a disclosure that there is funding and a disclosure that the Therium entity is funding it. That can lead to applications for security for costs, not against the funder generally, depending on the arbitral rules, but against the claimant. I think in my experience, we haven't seen those applications succeeding against claimants by dint solely of the fact that there's a funder sitting behind them. And I think my sense is that the tribunals, as it were, whilst on the one hand they've perhaps given respondents more ammunition with respect to disclosure, on the other hand they've probably taken that away in terms of their sensible approaches that we've seen to the question of whether security should be ordered in favour of a claimant because they are simply funded. It's a very complicated question. There are numerous factors, of course, but cutting through it all, tribunals appear to have said that only in exceptional circumstances ought security to be provided in those cases. I mean, adverse cost is an interesting one. Most of the arbitrations that we fund will say to the claimants, look, do you want to cover off the adverse cost risk? It's in your interest to do so. Less so in terms of the funder being in the crosshairs as we might be in other jurisdictions. And we've got the ability to provide an indemnity with respect to the adverse costs. And a lot of the claimants are particularly concerned about that for obvious reasons. But of course, in certain of the cases I've been involved in, the presence of that indemnity or as it were, freestanding ATE adverse after the event insurance policy is one of the factors that militates against the making of an order of security for costs against the claimant. So they're two sides of the same coin, but are relevant for these purposes.
Thank you. I mean, arguably one result of the disclosure of the fact of funding is it better positions the funded party to seek to recover the costs of funding and any success fees payable out of the sums collected to a funder. I'm thinking about SR and Norscop in England and a very recent case in the Supreme Court of Delaware, Shareholder Representative Services and Shire US Holdings. I mean, you fund a large number of cases now. Well, what's been your experience? Are parties now seeking to recover the success fee and what sort of attitudes and approaches are you seeing from tribunal if that is something that's happening?
Well, of course, the founding authority on the interplay between funding and costs was the Carter-Stopoulos and Fuchs matter against the Republic of Georgia, where I think at the end of the successful case, the respondents sought to say, well, the claimant shouldn't really be able to recover their costs because they didn't fund them. And, a strong tribunal gave that short shrift. We've moved on from that. Initial step has been built upon. And we are involved in a number of cases where not only have the claimants sought to claim at the end their funding costs, but also they've actually pleaded it as a head of loss. Very simple causation point, but for the wrong of the respondent state in most cases, we would not have had to pursue these proceedings and would not have had to have incurred the expense of funding to do so. I'm waiting for there's a couple of cases where the pleading point has been adopted, the pleading route has been adopted. I'm awaiting to see what the tribunals say about that. But I think as a quid pro quo of the disclosure, of course, if you want to recover your funding costs or at least have an argument on that, you need to make that front and centre of your case. You can't raise it right at the end, and so it goes hand in hand really with disclosing that the case is funded. So we're seeing that more and more, and in fact, after ESSA and energy. Particularly in this jurisdiction, one might say that lawyers are duty bound to advise clients who are funded to seek recoverability of those funding costs on success.
Without sort of disclosing anything confidential, what jurisdictions are those arbitrations where there are claims to recover the costs? Are they all seated in London, or are they elsewhere in the world?
No, they're elsewhere. I mean, they're within the established institutions, ICSID, for instance, but they're not constrained to this jurisdiction.
Thank you very much, Tim, for sharing your thoughts on those issues. I think we've covered quite a lot of ground. Many thanks for taking the time and the trouble to join us today. Thank you very much.
Not at all. It's a pleasure to speak to you. Thank you very much.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.